England's present interest discovered, with honor to the prince and safety to the people. In answer to this one question, what is most fit, easy, and safe at this juncture of affairs to be done? For composing, at least quieting of differences, allaying the heat of contrary interests, and making them subservient to the interests of the government, and consistent with the prosperity of the kingdom, presented and submitted to the consideration of superiors. Here are the three fundamentals comprehended and expressed to have been the rights and privileges of Englishmen. Ownership, consisting of liberty and property, in that it supposes Englishmen to be free, there's liberty. Next, that they have freeholds, there's property. That they have the voting of their own law, for that was an ancient free custom, as I have already proved, and all such customs are expressly confirmed by this great charter. Besides, the people helped to make it. An influence upon and a real share in the judicatory power, in the execution and application of law. This is a substantial part, thrice provided for in those 16 lines of the Great Charter by us rehearsed, that no amercement shall be assessed but by the oath of good and honest men of the vicinage. Nor we shall not pass upon him, nor condemn him, but by a lawful judgment of his peers, or by the law of the land, which is synonymous, or a saying of equal signification with the lawful judgment of peers. For law of the land and lawful judgment of peers are the proprium quarto modo, or essential qualities of these chapters of our Great Charter, being communicable omni soli and semper to all and every clause thereof alike. Chief Justice Coke well observes that per legem terrae, or by the law of the land, imports no more than a trial by process and a writ original at common law, which cannot be without the lawful judgment of equals, or a common jury. Therefore per legem judicium parium, by the lawful judgment of peers, and per legem terrae, by the law of the land, plainly signify the same privilege to the people, so that it is the judgment of the free men of England which gives the cast and turns the scale of English justice. These things being so evidently proved by long use in several laws to have been the first principles or fundamentals to the English free government, I take leave to propose this question: what may the free people of England be? May the free people of England be justly disseised of all or any of these fundamental principles without their individual consent? Answer: with submission to better skill, I conceive not, for which I shall produce first my reasons, then authorities. Through the British, Saxon, and Norman times, the people of this island have been reputed and called freemen by kings, parliaments, records, and histories, and as a son supposes a father, so freemen suppose freedom. This qualification imports a supreme right, such a right as beyond which there is none on earth to disfree them, or deprive them of it, therefore an unalterable, fundamental part of the government. If salus populi be suprema lex, the safety of the people the highest law, as say several of our ancient famous and lawyers and law books, then since the aforesaid rights are as the sinews of this free body politic, or that sovereign cordial without which this free people must needs consume and pine away into utter bondage, it follows they are the highest law, and therefore ought to be a rule and limit to all subsequent legislation. The estate goes before the steward, the foundation before the house, people before their representatives, and the Creator before the creature. The steward lives by preserving the estate, the house stands by reason of its foundation, the representative depends upon the people, and the creature subsists by the power of its Creator. Every representative in the world is as the creature of the people, for the people make them, and to them they owe their being. Here is no transubstantiating or transubstantiating of being from people to representative, no more than there is an absolute transferring of a title in a letter of attorney. The very term representative is enough to the contrary. Wherefore, as the house cannot stand without its foundation, nor the creature subsist without its Creator, so can there be no representative without a people, nor that people free, which all along is intended, as inherent to and inseparable from the English people, without freedom, nor can there be any freedom without something be fundamental. In short, I would fain know of any man how the branches can cut up the root of the tree that bears them, how any representative that is not only a mere trust to preserve fundamentals, the people's inheritance, but that is a representative that makes laws by virtue of this fundamental law, that the people hath a power in legislation, the second principle proved by me, can have power to remove or destroy that fundamental. The fundamental makes the people free, this free people makes a representative. Can this creature unqualify its Creator? What spring ever rose higher than its head? The representative is at best but a true copy, an exemplification. The free people are the original, not cancelable by a transcript. And if that fundamental that gives to the people a power of legislation be not annullable by that representative, because it makes it what it is, much less can that representative disseise men of their liberty and property, the first great fundamental, that is the parent of this other, which entitles to a share in making laws for the preservation of the first inviolably. Nor is the third other than the necessary production of the two first, to intercept arbitrary designs and to make power legal. For where the people have not a share in judgment, that is, in the application, as well as making of the law, the other two are imperfect, open to daily invasion, should it be our infelicity to have a violent prince. For as property is every day exposed, where those that have it are destitute of power to hedge it about by lawmaking, so those that have both, if they have not the application of the law but the creatures of another part of government, how easily is that hedge broken down, and indeed, as it is a most just and necessary, as well as ancient and honorable custom, so it is the prince's interest, for still the people are concerned in the inconveniencies with him, and he is freed from the temptation of doing arbitrary things and their importunities, that might else have some pretense for such addresses, as well as from the mischiefs that might ensue such actions. It might be enough to say that here are above 50 statutes now in print, beside its venerable antiquity, that warrant and confirm this legal judicium parium suorum, or the trial of Englishmen by their equals. But I shall hint at a few instances. The first is the Earl of Lancaster, adjudged to die without lawful trial of his peers, and afterwards Henry Earl of Lancaster, his brother, was restored. The reasons given were two: one, because the said Thomas was not arraigned and put to answer; two, that he was put to death without answer or lawful judgment of his peers. The like proceedings were in the case of John of Gaunt, and in the Earl of Arundel's case, but above all, that attainder of Thomas Cromwell, Earl of Essex, who was attainted of high treason, of which saith Chief Justice Cook, as I remember, let oblivion take away the memory of so foul a fact if it can; if not, however, let silence cover it. 'Tis true, there was a statute obtained in the 11th of Henry VII in defiance of the Great Charter, which authorized several exactions contrary to the free customs of this realm, particularly in the case of juries, both cessing and punishing, by judges of assize and of the peace, without the fining and presentment of 12 freemen. Empson and Dudley were the great actors of those oppressions, but they were hanged for their pains, and that illegal statute repealed. The consequence is plain, that fundamentals give rule to acts of Parliament, else why was the statute of liveries and information, by the discretion of the judges, to stand as an original, and this of the 11th of Henry VII repealed as illegal? For, therefore anything is unlawful, because it transgresseth a law. But what law can an act of Parliament transgress but that which is fundamental? Therefore trial by juries or lawful judgment of equals is by acts of Parliament confessed to be a fundamental part of our government, and because Chief Justice Cook is generally esteemed a great oracle of law, I shall in its proper place present you with his judgment upon the whole matter. These fundamentals are unalterable by a representative, which were the result and agreement of English freemen individually, the ancienter times not being acquainted with representatives, for then the freemen met in their own persons. In all the Saxon story we find no mention of any such thing, for it was the king, lords, and freemen, the elders, and the people. And at the Council of Winton in 855 is reported to have been present the great men of the kingdom and an infinite multitude of other faithful people. Also that of King Ina, the common council of the elders and people of the whole kingdom. It is not to be doubted but this continued after the Norman times, and that the freemen of England were personally present at the confirmation of that great charter in the reign of King John. But as the ages grew more human, and the number of freemen increased, there was a necessity for a representative, especially since fundamentals were long ago agreed upon, and this capital privilege put out of the reach and power of any little number of men to endanger. And so careful were their representatives in the time of Edward III of suffering their liberties and free customs to be infringed, that in matters of extraordinary weight they would not determine till they had first returned and conferred with their several counties or boroughs that delegated them. And lastly, if these ancient fundamental laws, so agreeable with nature, so suited to the disposition of our nation, so often defended with blood and treasure, so carefully and frequently ratified, shall not be to our great pilots as stars or compass for them to steer the vessel of this kingdom by, or limits to their legislation, no man can tell how long he shall be secure of his coat, enjoy his house, have bread to give his children, liberty to work for bread, and life to eat it. Truly, this is to justify what we condemn in Roman Catholics. It is one of our main objections that their church assumes the power of assuring people what is religion, thereby denying men the liberty of walking by the rules of their own reason or precepts of Holy Writ. To which we oppose both. We say the Church is tied to act nothing contrary to reason, and that Holy Writ is the declared fundamental law of heaven, to maintain and not to usurp, upon which power is given to the true Church. Now let us apply this argument to our civil affairs, and it will certainly end in a reasonable limitation of our legislators, that they should not impose that upon our understandings which is inconsistent with them to embrace, nor offer any the least violation upon the fundamental law of the land, from whence they derive their power to prosper such attempts. Have we not long told them that under the pretense of obeying the Church and not controlling her power, she hath raised a superstructure inconsistent with that foundation she pretends to build upon? And are not we the men in civils that make our grand privileges to depend upon men, not laws, as she doth upon councils, not Scripture? If this be not popery and temporals, what is? It is humbly beseeched of those superiors that it would please them to consider what reflection such severity justly brings upon their proceedings, and remember that in their ancient delegations it was not to define, resolve, and impose matters of religion, and sacrifice civil privileges for it, but to maintain the people's properties according to the ancient fundamental laws of the land, and to superadd such statutes only as were consistent with and preservative of those fundamental laws. To conclude this head, my plain and honest drift has all along been neither more nor less than this, to show that church government is no real part of the old English government, and to disentangle property from opinion. The untoward knot the clergy for several ages have tied, the which it is not only the people's right, but our superiors' interest to undo, for it galls both people and prince. For where property is subjected to opinion, the Church interposes and makes something else requisite to enjoy property, than belongs to the nature of property, and the reason of our possession is not our right by and obedience to the common law, but conformity to church law, a thing dangerous to civil government, for 'tis an alteration of old English tenure, a suffering the church to trip up and supplant the state, and a making people to owe their protection not to the civil, but ecclesiastical authority. Make English men's rights as inviolable as English church rights, disentangle and distinguish them, and let not men sustain civil punishments for ecclesiastical faults, but for sins against the ancient established civil government only, that the natures of acts and rewards may not be confounded. So shall the civil magistrate preserve law, secure his civil dignity and empire, and make himself beloved of English men, whose cry is, and the cry of whose laws has ever been, property more sacred than opinion, civil right not concerned with ecclesiastical discipline, nor forfeitable for religious nonconformity. Several authorities in confirmation of the reasons. So indubitably are these fundamentals the people's right, and so necessary to be preserved, the kings have successively known no other safe or legal passage to their crown and dignity than their solemn obligation inviolably to maintain them. So sacred were they reputed in the days of Henry III, that not to continue or confirm them were to affront God and damn the souls of his progenitors and successors, to depress the church and deprave the realm, that the great charter comprehensive of them should be allowed as the common law of the land by all officers of justice, that is the lawful inheritance of all commoners, that all statute laws or judgments whatsoever made in opposition thereunto should be null and void, that all the ministers of state and officers of the realm should constantly be sworn to the observation thereof, and so deeply did after parliaments reverence it, and so careful were they to preserve it, that they both confirmed it by 32 several acts, and enacted copies to be taken and lodged in each cathedral of the realm, to be read 4 times a year publicly before the people. as if they would have them more obliged to their ancestors for redeeming and transmitting those privileges than for begetting them, and that twice every year the bishops, apparelled in their pontificals, with tapers burning, and other solemnities, should pronounce the greater excommunication against the infringers of the great charter, though it were but in word or council, for so saith the statute.